Court-employed mediators working in family court services are required to have a master's degree or higher in behavioral science, such as psychology, social work, marriage and family, or child counseling. Mediators have a minimum of 3 years post-master's experience, extensive knowledge of child development, the court system, and community resources. In addition, court-connected mediators are required to complete 12 hours of continuing education annually, with 4 of these hours focused on domestic violence. Mediation only involves the legal parents or guardians and the mediator. Each parent is given an opportunity to present their proposal for how they want the timeshare and custody of their child to be. Usually the parent who filed the current request for court orders generally speaks first. The mediator will facilitate the conversation between the parents to negotiate and compromise in order to help you reach an agreement. Remember, the mediator is a neutral person and does not take sides. It is the mediator's job to provide education and suggestions to assist parents with their parenting plan. In preparing for your mediation session, it is important to keep an open mind and come ready to discuss different options for sharing time with your child and the other parent. Mediation is not about winning or losing. It's about problem solving. Remember, this is about your child's best interest, and children do best when both parents are involved. Take time to consider the other parent's proposal. Offer another solution rather than rejecting it completely. Even minor compromises can go a long way in developing a plan that both parents are willing to live with. Try not to place blame or focus on the negative feelings you may have about the other parent. We understand this is a difficult and emotional time. However, letting your emotions and past history influence your decisions will only negatively impact your child. Your child has their own relationship with each parent that should be encouraged and valued. Now, let's talk about the possible outcomes of mediation. Over 50% of parents are able to work out a parenting plan in mediation. When an agreement is reached, the mediator will format the document and provide parents with a copy for review prior to leaving the session. If both parents verbally approve, the mediator will forward the plan to the judicial officer to sign, at which time it becomes a court order. Many times, parents may reach a partial agreement. This means that there are one or more unresolved issues in which both parents are proposing different options. One common example is the label of custody. One parent may be requesting sole custody, and the other parent may be requesting joint custody. In this case, the mediator will write up the parts of the plan that both parents are in agreement with and indicate that the court needs to decide the label of custody. At the end of this orientation, you will be directed to sign twice on the consent form. The first signature indicates you understand the process of mediation. The second signature allows the mediator to share the specific issues to be determined by the court when a partial agreement is reached. Although the ultimate goal in mediation is to reach a parenting agreement, sometimes there are circumstances or safety concerns that prevent this. When parents do not reach an agreement, the mediator may suggest several options to assist the court. One option is for parents to return for further mediation. This is helpful when parents have recently separated, or you may still be residing in the same residence. Sometimes a period of time is needed for everyone to adjust to the separation. The initial mediation session can provide education and options of different plans for parents to think about, and then they can return prior to the hearing or be referred the same day as your hearing to write up the plan. Mediators can also meet with your child. If parents express differing views of what their child has expressed to them, sometimes it's helpful for the mediator to speak with the child and then meet with the parents again to provide feedback. Mediators will use their discretion in deciding to interview a child. Typically, this occurs when both parents agree for the mediator to meet with their child. Mediators are trained to be sensitive regarding the separation process and never ask a child to choose sides between parents. In addition, information shared by the child would be confidential and not shared with the court. An attorney for the child may also be suggested in cases when the child is very young and cannot express themselves verbally, when there are medical or psychological needs, or if there are highly conflicting views by both parents regarding their children's preference. When an attorney is appointed for your child, they represent the child and would provide any needed information to the court. Parents are responsible for paying any attorney's fees. In cases where there is extremely high conflict or where there are safety concerns such as child abuse, drug and alcohol abuse, criminal history, or domestic violence, the mediator may suggest a child custody investigation or a 730 psychological evaluation. Custody investigations are completed by court-appointed mediators and consist of interviews with both parents and all children over the age of 6. In addition, police, social services, and criminal records are reviewed, and then a written report is provided to the court with recommendations for custody and visitations. A 730 evaluation is conducted by a community-based licensed psychologist who evaluates the parent-child relationship through interviews and psychological testing, and then provides recommendations for custody and visitation. Both types of evaluation are very costly, and the parents are financially responsible. When none of these options are applicable, then parents are referred to court, and the judge will decide what to do. Now, take a moment and respond to a few questions.